Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's presidential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Any of you guys ever heard of Ira Kurzban? Of course you have. He's the immigration GOAT, both literally and figuratively. Well, I spoke with him about the Supreme Court's 2023-2024 term in mid-July. Among other things, we discussed the state of the federal judiciary and some Supreme Court decisions that weren't really about immigration per se, but that will have a big impact on immigration and the United States generally. Decisions that I haven't discussed on the podcast previously. Give this interview a listen and transport yourself back to law school. Ira is, of course, also the author of Kurzban's Immigration Law Sourcebook, and the new, fully updated 19th edition is currently at the printer and slated for release later this summer. The new edition includes updated analyses of Supreme Court decisions from the most recent term, more than 1,000 new cases from federal court and administrative agencies, and all immigration-related regulations, policy updates, and government announcements from the past few years. I don't know how he does it, I truly don't. If you haven't ordered your copy yet, you can visit ayla.org/Kurzbans to place your order. Depending on how early you order, AILA members get a pretty nice discount on this essential resource, so don't delay. Act now. Plus, it's pink, and as any good Barbie fan knows, that goes with everything. Please enjoy this conversation with Ira Kurzban. Ira Kurzban, welcome back to the Immigration Review Podcast. It's July 12th, 2024 in the evening. How you doing?
How you doing, Kevin? What a pleasure.
I'm doing fantastic. I'm a lucky man to get Ira Kurzban on the show as often I did. I believe this is your third appearance now. If you don't know, I truly am curious how you know about this podcast or practice of immigration law. If you don't know Ira Kurzban, he is the man, the myth, and the legend. Ira Kurzban, first of his name, Lord of Immigration Attorneys, writer of books, founder of KKTP, suer of governments, protector of Haitians and all immigrants, and why not, mother of dragons. That is who Ira Kurzban is, and I'm fortunate to have you on the show tonight to talk about the Supreme Court.
Well, Kevin, I could give you a gratuity afterwards because that's not considered a bribe, but I appreciate it.
That's exactly.
All right, so I'd like to begin by talking to the listeners, not as an immigration lawyer, but simply as a lawyer concerned about the Supreme Court and the current status of our legal system. The decisions we will discuss today are part of a 50-year project to change the legal culture of the U.S. They're not independent, discrete decisions, but in my view, at least, a full-scale attack on the administrative state and an unrestrained effort to destroy what most Americans, I believe, want, which is bolstering the rule of law, holding businesses accountable under a restrained form of capitalism, clearly separating church and state, recognizing that no person is above the law, and developing individual rights for all Americans. That's what I think most Americans want from our legal system and from our country. So big business in the US and the politicized business community represented by families like the Koch family and other zealots, as early as the 1970s, decided to invest in changing America. From their perspective, it was and remains an investment. If they can change the culture to deregulate and not protect American citizens, their wealth and the wealth of their corporations will increase dramatically. And that's the context that I'm trying to put these cases in.
As listeners might be able to tell by now, we are not pulling any punches tonight. These views are the views of Ira Kurzban, whether or not I do or do not agree with them. And we're actually taking a unique perspective on this podcast tonight. We're not going to talk about Wilkinson, Munoz, Campos Chavez,
Brown.
We're not going to talk about the immigration specific or really immigration adjacent cases tonight. I've talked about them a lot on the podcast. Everybody's talking about them. We're going to talk about Loper Bright, but we're going to talk about the other big cases that affect us as lawyers and us as U.S. citizens and people of the world. And, you know, immigration lawyers are people too. So it might affect immigration law as well. But we're talking about the deep stuff tonight, right?
Yep.
You say this is a big conspiracy beginning in the 1970s. How did it happen?
Well, basically, it happened. Justice Powell, before he became a Supreme Court justice in 1971, wrote a famous memo that basically said we need to change the culture of the U.S. It's not enough for big business, which was looked at very unfavorably in the 70s, that we really have to change the culture and not just, give money to politicians. So that's when we got the beginnings of what we today call dark money. And how did it happen? They started to give money to universities like George Mason, which were heavily endowed to develop programs for deregulation. Law schools were established preaching the gospel of anti-abortion and deregulation. Grassroots organizations were funded. For example, people believed the Tea Party was a spontaneous uprising in America. In fact, it was heavily funded by the Koch family. And even today, it's been reported repeatedly in the press that organizations claiming to be environmental organizations that say wind power is destroying America are all funded by big oil and other companies. But I think one of the major developments has been the establishment of the Federalist Society, in contrast to the ABA, which politicizes and recruits lawyers and judges who have anti-immigrant, anti-abortion, anti-regulation, anti-administrative state views, and have really, in many respects, unfortunately, a political agenda. And in that agenda is the idea of a unitary, all-powerful executive that could carry out this ultra-conservative agenda. And we'll see that in the decisions that we talk about today. The case I want to talk about, Kevin, represents some of the most extreme forms of these doctrines. Not only the substance of the cases are far out of the American mainstream in beliefs, but they were issued in a very interesting way. They were issued in a rapid fire succession over a 3 or 4 day period.
Yeah.
And what I regard in a calculated way, what I call shock and awe, legal shock and awe. They were released by the Chief Justice in such a manner that their effect was to overwhelm the U.S. public and the legal community. For example, even though the special counsel asked for a quick resolution months ago on the Trump immunity issue, Chief Justice Roberts held that opinion until the very last moment of the term on July 1st. Other monumental decisions like Loper Bright, Corner Post, Jarkessi, Fisher, and Snyder, which I'll talk about today, were all issued within a few days of each other at the end of the term, with some being issued the same day. This kind of, quote, shock and awe, end quote, approach is quite revealing, considering the court this year had relatively few cases on its docket.
I get that feeling as well, Supreme Court watcher that I've become. And, maybe this is what happens, Ira, when you, like yourself, have been a Supreme Court watcher for over 4 decades. You start seeing these patterns and you can't help but view things other than through the light that we learn in law school. And that is that these are just judges applying the law. Maybe they have different legal philosophies, but that's all this is. Before we get into these specific cases, and we're going to talk about Loper Bright first, how are we as lawyers and immigration lawyers supposed to think about being lawyers when the Supreme Court is showing us that they might, at least 6 conservative justices, might not always be operating in good faith and are certainly operating with a goal in mind, that they are sometimes end-oriented? How are lawyers supposed to deal with that? They still are the ultimate arbitrators in the highest court in the land.
Well, I think certainly one thing, Kevin, is that we should be very reluctant to bring cases to the Supreme Court,
no
matter how bad the decisions are in the lower courts. And I must say, I was probably guilty of that as well as everyone on the Patel case. But I think what we're seeing is clearly a pattern, particularly on jurisdictional issues, to some extent to restrict the ability to bring cases. The one exception, I think, is Wilkinson, but Wilkinson followed Guerrero before. So that's one, you could say, bright spot about it. But generally, the court's been pretty bad on immigration matters, and I think will continue to be so. And there always seems to be at least 5 votes, sometimes pick up one vote or another. But Justice Barrett seems to be leading the charge on the most restrictionist views with respect to immigration issues.
I don't think that you can. I mean, I guess textualism, statutory interpretation is open to interpretation. I don't see how you can view Justice Alito's statutory interpretation in Campo Chavez as anything more than ends-oriented judging, which the dissent, including Justice Gorsuch, make very clear. And I'm sorry, I'm not going to let it slide, Ira. I don't. You're a very humble person. Patel, you know as well as I do that the 11th Circuit went in banc sua sponte, appointed you the attorney, and then lost the votes on en banc that the en banc judges thought they had, which led to the loss, and that we had no choice but to go to the Supreme Court. And so I'm not going to let you get away with taking blame for Patel, which, oh, by the way, probably goes the other way if Justice Ginsburg doesn't die on the bench. So just going to tell the whole story there.
Well, that's kind of you, but it's a case that shouldn't have been brought ultimately.
Oh.
I think, to the Supreme Court. I thought, in fact, to this day, I am truly amazed at that decision. When you have the government on your side,
correct,
and you have the presumption of judicial review, it is, I think, unique to find a decision like that kind of decision. But so it is.
We keep getting Justice Gorsuch in dissent on immigration decisions. I'll give him that. In the bad ones. So let's talk about Loper Bright, Ira.
My colleagues, my immigration colleagues, cheer this decision and make it easier to attack anti-immigrant views of DHS. The first point is that they missed the obvious, I think. And Loper Bright, of course, is the decision that ended Chevron deference, but it's a two-way street. And I remind my colleagues that the first immigration attack using Loper Bright was not brought by a pro-immigration group, but rather the Washington Alliance of Technology Workers, making it a new basis to challenge their claim that H-4 spouses should not get work permits. So this is going to fluctuate, obviously, depending on the political point of view of the executive branch and how they either want to extend benefits to people, but if they try to extend those benefits, you're going to get arguments that the agency should not be accorded deference. So it really is a two-way street. But what is Loper-Bright after all? Justice Kagan, in a stinging dissent, where she noted the reversal of more than 40 years of law under Chevron deference, called it nothing more than judicial hubris. It involves deference, it removes deference, from experts and policymakers steeped in any agency area and turns over those decisions on highly technical and policy questions to federal judges who do not have the expertise and really carry their own political baggage, as do many Federalist judges when making those decisions.
Yeah.
So, it was interesting to me. Justice Kagan pointed to the, quote, hubris of the majority and thinking that a federal judge, de novo, without deference to the agency, could address problems for years that can answer such questions as, and then she listed a number of questions. One, whether an alpha amino acid polymer qualifies as a protein under the Public Health Service Act that the FDA regulates.
That's an easy one.
Or what is a, quote, distinct population segments of a species, end quote, and whether the western gray squirrel should be treated as such under the Endangered Species Act. Or how much noise is consistent with the, quote, natural quiet, end quote, over the Grand Canyon from flying aircraft under the Department of Interior and FAA regulations. These are not only decisions by experts, but policy choices guarding the statutes that generous federal judges should not be deciding without deference to the agency. The big fraud here, I think, in Loper-Bright is this idea that somehow Congress, if they want to fill in these gaps, should write these statutes more specifically. And that's a total joke, of course, because when Congress regulates, they only regulate in a very generalized level, always have, and they can never anticipate the future. And the idea is to have the agencies that have developed long-term expertise, and whether that's true of immigration or the EPA or any other agency, that have the expertise to make a decision and have the policy background to make those decisions. And, it's not as if, Kevin, the agencies get a free pass. People say, well, immigration always makes the wrong decision and so forth. But they don't get a free pass under Chevron. If the statute is not clear, then the interpretation still has to be reasonable and can be reviewed by a federal court for reasonableness. But here we are now, left with judges who may have biased views of environmental protection. And I can tell you, immigration law, by having read most of the decisions in the last several years, many of which were by Federalist judges, or government authority to regulate, and profoundly lack the expertise as generalists sitting in federal courts.
Hey, you're absolutely right. Chevron, all it does is, first of all, the circuit court or the district court judge has the initial and uninfringible right to determine whether a statute is ambiguous or not. The agency doesn't get any deference there, and only if it's ambiguous does the agency's reasonable interpretation get deference. It puts a slight thumb on the scale to agency interpretation. And correct me if I'm wrong, in the non-immigration context at least, it also kind of stems the floodgates a bit on litigation, because litigators know that they don't want to waste a lot of money in what is ultimately going to be a judgment call, and they know that Chevron requires deference to the agency. But now you can litigate agencies to death. And I think with the immigration bar that is giddy about this, putting aside the 11th Circuit getting a little cute with maybe like uber deference to the Attorney General and the INA, putting that aside, I think the immigration bar is a little giddy because they're only thinking about the BIA. And over the last, 10, even 15 years, the majority of BIA decisions have maybe not been so friendly to the non-citizen bar. Although think about Matter of Richmond, there are good ones and they abound. But, they're not thinking about the regulations like you just mentioned with the H-4 and how whatever Biden's parole program, his interpretation of parole in place is going to be. So it's a narrow focus on the BIA, I think, with the immigration bar. What do you
Right.
think?
And I think the reality is what you just said, which is, first of all, from the bigger perspective, not only immigration, but everything, this is an open invitation to litigate and force the administrative state, the administrative agencies to do less and less and less regulation and to overwhelm them so that, passing environmental regulations or regulations involving drugs or regulations involving agriculture or regulations involving the Food and Drug Administration are going to be more narrowly focused and far fewer because they're going to be subject to endless attacks by big pharma, big oil, big agriculture, which have unlimited resources to fight these cases.
Well, Ira, where's big immigration then?
Well, big immigration is the federal courts.
The non-citizen bar could create big immigration to litigate away, just like big oil, big pharma, big ag,
I think the
immigrants
issue is
list.
going to be when you have organizations like the Washington Alliance of Technology Workers, you're going to start seeing a lot of litigation challenging what we regard as positive developments. The states have taken that up now, but you may have, different organizations start challenging all the positive, administrative decisions that we've seen. Like you're talking about parole in place. It's a good example. You go before a judge who has Federalist views about immigration. And I think what's going to happen is they're going to strike down all this stuff as inconsistent in their view with the statute. But basically the strategy here, whether it's immigration or anything else, is to overwhelm the agencies with litigation where their views are not given deference. And then the regulations will dwindle and the corporations will be free to engage in unrestrained capitalism. Generally, when an agency makes rulings that protect the public, those opposing the regulations may now litigate every technical issue and use their oversized resources to fight every aspect of every regulation without giving agency deference.
With a world that is on fire, and I think it's 120 degrees in Scottsdale, Arizona today. It's very scary stuff. And I mean, but Chevron deference is dead. The floodgates are open. The winners of this would appear to be the entities that have been fighting for deregulation for years, the Koch brothers and other entities, who, by the way, were behind the Loper Bright fishermen. Bad facts sometimes make bad law, not to get into the facts there. But I mean, when your litigation is being funded by entities, it's pretty clear who wants to benefit. And so the effect of Loper Bright, of course, remains to be seen. It's only been a week or two. But I mean, it wasn't just Loper Bright, right? Corner Post happens then, like right next to it. What no one's talking about Corner Post, but people who know are freaking out about Corner Post. What is Corner Post?
Well, let me talk about Corner Post. The 6-member Federalist majority, not content with just having Loper Bright prospectively, then issued Corner Post. And Corner Post is a decision which will extend the statute of limitations indefinitely on any regulation and allow litigation regarding every single administrative decision that has been made in the past half century. Why? Corner Post has extended the APA statute of limitations indefinitely by defining the 6-year statute under the APA as applicable from the day the person is affected by the decision and not by the date the regulation was issued. Any plaintiff who's been affected by a regulation in the last 6 years may now initiate an APA challenge, even if the regulation was issued decades ago.
Right.
Previously, a company could only challenge the government under the 6-year statutes from the issuance of the regulation. So if Big Oil and the Coke companies now want to challenge a regulation that has existed for years under the Clean Air, Clean Water Act, they need only set up a new company that is now affected by a 20-year-old regulation of the EPA because the limitation periods run from the time the company was affected and not when the regulation was promulgated. There are exceptions under the Hobbs Act where you have to file an appeal as written in the statutes within a 60-day period. As you know, we have some of the Hobbs Act issues in immigration as well. But generally, this is open season for the APA. Now, you may ask me, well, it doesn't seem that corner post benefits non-citizens seeking to overturn bad immigration policy. In other words, there may be a benefit to an immigrant who can now challenge an old rule applied today against him or her.
An old regulation. We're not talking about BIA decisions because that's, of course, case-by-case adjudication.
That's correct. Although I suppose when a decision is applied, does the APA allow you to challenge an old board decision? No, if it adversely affects you and you can go to district court and you can claim, let's take the issue on whether or not you can challenge ineffective assistance of counsel. And it's based on a decision, as we know.
Matter of Lozada.
Lozada.
Matter of Lozada.
Right. And so you're a lawyer who's affected now, or you're a client who's affected by ineffective assistance, and they come up with Lozada. I don't see why you couldn't, if you're not otherwise in a removal proceeding, let's say it's in a action to retroactively grant somebody a benefit, EB1 case that went bad because the lawyer was ineffective, but you didn't sue the lawyer, and they say, well, you didn't sue the lawyer. I don't know, maybe you can go into federal court on an APA challenge on that, irrespective of when the decision was rendered.
I mean, the Band-Aid's been ripped off, certainly, for challenging regs. But I guess my point was, even for matter of Lozada, usually that's going to begin in removal proceedings, and you can always challenge matter of Lozada in your specific case before the BIA, urge the BIA to vacate matter of Lozada or distinguish or clarify it, and then once you're at the circuit, urge the circuit to, no deference, I'll tell you that, because there's no Chevron. There was no statute of limitations in removal proceedings. I guess that's what I'm saying here.
Yeah, and I think that's right. And I think one of the things that can happen is when people are litigating these cases, and you make a very good point, like let's take Lozada, people should really look at a strategy or have a strategy to challenge deference where those decisions were based on deference.
Right.
So we can go back, any decision where that was based on deference, it seems to me, can be challenged. But, in immigration, when the 6 justices ruled in Loper, Bright, and Corner Post, my view is you can rest assured that they weren't thinking about immigrants. They have many other ways of dealing with immigrants by simply closing down the right to sue, as they did in Munoz this term, or Patel and Thurasajam several terms past, or in the next term, where I think they'll decide that immigrants cannot sue on revocation of immigrant petitions and possibly not sue for reconsideration of voluntary departure. So, this idea that somehow this is going to be a fountain of litigation for immigration lawyers, I think misses the point when we look at all the decisions that preclude judicial review in many different forms.
Well, they're not going to affirm the agency in the 11th Circuit on the revocation of immigrant petitions if you and Eddie have anything to say about it in amicus. And we're talking about matter of Lozada. How about Senator Murphy's proposed bill to get rid of Lozada yesterday? It's good to see the legislature taking some action, even though it probably doesn't go anywhere for now. And it's good to see it being focused on for the immigration bar.
And the podcaster here may have had a little bit to do with that. Hopefully.
No, I try. It's an important issue. It makes if nothing else, it makes the practice of immigration law unnecessarily stressful. Before we get to Jarkissi, I want to ask you the same thing I asked Eric Lee, who was the lead attorney on Munoz, who I interviewed a couple of weeks ago and who argued Munoz before the Supreme Court. How do you explain Munoz and Loper Bright coming out a week later? If you read the Chief Justice's Loper Bright decision, you would come away thinking that there's been this egregious wrong in 1984, taking any power away from the judiciary to let the executive run free and to have even a mere little thumb on the scale of the executive, that is this egregious wrong, and that you must have open judicial review. And Munoz, they literally affirm the doctrine of consular non-reviewability and put up a wall around the whole thing that might be impenetrable. Department of State is also an administrative agency. How in the world do you explain those two decisions issued a week apart? Please.
Three different ways. Federalists are anti-immigrant. Federalist judges are anti-immigrant as a group. I mean, it's very rare that you see them come out the other way. If and they were picked in part because of their anti-abortion views, their immigration views, and so forth. So, we have a court that is insensitive, I think, to those kind of issues. Secondly, you have a court that's already said there are people above the law. If they can say the president of the United States is above the law, it's not too difficult to say that a consular officer is, in some respects, above the law. In other words, they're recognizing, even on the facts of Munoz, that there was a clear error, and they're saying, well, you can't sue anyway because there's this doctrine,
that we made up,
doesn't permit suit. The other part of this, though, is a longer term project of the Federalists, which is to use an old Supreme Court case and to revamp what due process means by then going back and saying, well, there's no due process rights unless they were, originalist due process rights. And so I think that's part of what's happening in Munoz, which is their view of due process. It's a very different view than what we've had for many, many, many years.
I just thought administrative agencies were evil. I read Loper Bright and I learned that administrative agencies are horrific and that they must be reviewed by the judiciary. But I mean, the Department of State is an administrative agency, so I'm not a smart person, Ira. I don't understand how those two things can be the same.
Well, you're a very smart person, but you don't want to reach the conclusion that a man my age would say which is it's all political. These people were put on the court for political reasons, and they're doing what they were put on the court for. You can use all the analysis that you want, but when you look at these decisions, they look awful lot like they are political in nature, anti-immigrant in nature, due process restriction. I think what I found interesting, my last point about Munoz, is the way that Justice Barrett reached out to redefine Kleindienst versus Mandel and a whole line of cases, which were not part of the decision, which were really not necessary to reach the decision that she reached. They could have left it at the constitutional issue, but they chose to write a very, very broad opinion. And I have to tell you, in reading all the lower court cases, this is a interesting and distinct feature of the Federalist judges, which is they will reach out to talk about issues that were definitely not necessary for the resolution of a case. And of course, we always learned in law school that that's the first rule, that you only reach issues that you need to.
Justice Barrett didn't overrule Mandel, and maybe the argument is that First Amendment rights are just more important than marriage. Mandel's not overruled. There still might be a path, right, for U.S. citizens.
Mandel is still there, but she did say it's not a constitutional in nature, which I find really peculiar given the way that the case was presented to the court in the 1970s, which was a First Amendment claim.
Right.
So to say it was not constitutional, the court in Mandel never said it wasn't constitutional. They said the way to resolve the constitutional question, which is the same thing they did in other cases following Mandel, is to say that the rights that are due somebody under due process are limited by the facially legitimate and bona fide standard. And that's what I meant about reading Munoz, not so much as this bad decision about consular review, but understanding it in the context of a very different view of due process.
So you've been singing the Jharkhasi song for months now about how the sky is falling, and the sky didn't quite fall with Jharkhasi, at least with immigration, but there's another case that not many people are talking about. What is Jharkhasi? What's it about? And how might it affect immigration?
Well, Justice Sotomayor said in dissent that it was nothing more than a power grab, and she's absolutely right. It was cloaked in the garb of the Seventh Amendment. It rips from administrative agencies the right to hold enforcement hearings where ALJs knowledgeable in the subject can issue financial penalties against an individual entity. Under the current system, as in Jharkhasi, an ALJ would hold a full APA evidentiary hearing and issue a ruling. The party would then have an appeal within the agency. It would then have an appeal to the Circuit Court of Appeals.
Mm-hmm.
As Justice Sotomayor pointed out, there are over 200 statutes in administrative proceedings, including those, by the way, for I-9s in immigration, that have similar features. Despite the Seventh Amendment, these administrative proceedings were protected for years under the public rights exception. In other words, it was always the case that you could say these belong to federal judges under the Seventh Amendment, but they carved out a public rights exception. Jharkhasi provides that exception does not apply where the remedy is a financial penalty and is a matter of common law. So this has now opened the floodgates on these 200 statutes to say the agency has no right to do this, that the administrative law judges have no right to exist because the procedure is contrary to the Seventh Amendment. However, the court vaguely describes the boundaries where the common law right will require trial by jury in federal court. They do carve out certain exceptions to this sweeping ruling that will invalidate hundreds of statutes. They say, well, it doesn't relate to Indian tribes or immigration law or administration of public lands or the granting of public benefits or aspects of customs law and the collection of revenues. Those are carved out under public rights exception. But they're really minor parts of the regulatory agencies that protect us as citizens.
So correct me if I'm wrong. I mean, just to recap, Jharkhasi is about SEC proceedings, the Seventh Amendment being the right to a jury trial, and they essentially said that for such proceedings, you need to do a full-on jury trial. You can't just have administrative law judges issuing these initial decisions. And that sounds really close to like a Social Security judge or an immigration judge. And what you're saying is that there's kind of this in passing sentence or phrase in the majority decision where it says, well, not those type of administrative judges, but the administrative judges that deal with money. In those cases, you need to have a jury trial, but not these other ones. I mean, you're about to say, what does it all mean? But it seems like there could be a challenge, and I don't know if it's a good thing or not, to the authority of immigration judges or other judges. It's certainly a foot in the door.
That's a different issue, and I'll get to that in a minute because, one of the things left open in Jharkhasi will go after the entire administrative state. But let me just finish on Jharkhasi. So companies, for example, that are fined for airplane or vehicle safety, like a part of the plane flying off in midair, as we've seen, pollution, poisonous food, making unsafe products, committing blatant frauds of all kind, they can now simply litigate those to death before a federal judge, where they'd be given much broader discovery, as you know, in a federal court than they would before an agency. So a company can spend millions of dollars fighting a financial penalty instead of complying, where fighting the case in federal court may make the agency the agency, the FAA, the people that protect us, more hesitant in the future to bring additional fines or penalties.
I'm sensing a theme of this podcast episode, and it seems to be tear down the agency framework so they can be litigated to death.
Right. I think that's right. And one of the areas in immigration, by the way, that I'm not sure is protected by this idea that, public rights include all of immigration, are I-9 penalties. I-9 penalties, it sounds like to me, are pretty much like the penalties in jarcossy. And I don't know whether or not somebody will bring that issue as to whether or not jarcossy applies in I-9 cases. But putting aside whether jarcossy exempts immigration, Roberts, in his decision, and Roberts is responsible for Loper Bright and this decision, leading the charge on the attack on the administrative state. Roberts ominously points out that there were two other constitutional issues not decided in jarcossy, which means they're going to be coming up in the next term or the term after.
That's how it works.
One of them is the non-delegation doctrine. And more importantly is the other, which is, quote, 2 layers of 4 cause removal protection violate the separation of powers. Think about that. The latter issue, is going to come back, and it's really at the heart of the administrative state, and is the attack, by the way, by SpaceX now and others to end all regulatory action in the U.S. that affects their business.
The doctrine of the non-delegation doctrine is essentially that Congress has the authority per the Constitution to do everything, really, and they cannot delegate that to an administrative agency.
Right.
And that the 435 individuals in the House plus the 100 in the Senate have to literally do everything. That is the doctrine, the non-delegation doctrine, right?
It doesn't quite go that far, but it's used as an excuse in many ways to prevent agencies and the executive, from acting. But here's the issue. Even immigration, and let me give an example. For example, if an immigration officer cannot be removed from his position without cause, and the Merit Systems Protection Board members cannot be removed without cause, then according to the issue that remains open in jarcossy, that system is unconstitutional. The ramifications of this are nothing less than giving a president the authority to directly control all immigration officers by allowing their removal without cause.
Isn't that Project 2025, except cloaked in judicial?
You bet.
That's just cloaked in judicial reasoning.
What it really means is we no longer have a bulwark against dictatorship. In other words, loyalty oaths, rather than following the law, will be the rule of the day. And when you combine that with Trump v. the U.S., this is potentially, in my view, the end of democratic rule with a president who sees himself as an autocrat. Whatever the failings are of the administrative state, it protected the American public from the whims and caprice of an iron-willed president who will bend all employees of the executive branch to do his bidding.
Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes.
Trump is already, and the 2025 lays out plans basically for removing a major segment of the federal government employees. And then I suppose if they're willing to sign a loyalty oath and kiss the ring of the president, then maybe they'll bring them back.
I'd be careful. I'd be careful talking bad about loyalty oaths, Ira. I do recall being forced to say one to you when you hired me. So, I mean, people who live in glass houses shouldn't throw stones, especially when they're from the same part of Brooklyn as Mr. Trump himself. So that's a eerie similarity there.
Yeah, but I'm from the same part of Brooklyn as Bernie Sanders.
All three of you just in one
and
house.
Larry David.
Oh, wow.
In fact, he went to my high school.
I mean, this is...
here's the issue. I don't think this is just hyperbolic. I don't think it's fear-mongering. You look at the Heritage Foundation 2025 blueprint,
Right.
and despite Trump's effort to distance himself from it, it was partially written, and actually mostly written, by many people who work for him. Gene Hamilton and Ken Cuccinelli, who wreaked havoc on the DOJ and DHS as Trump employees, including ending TPS.
Didn't we depose Gene Hamilton and TPS for Haiti? I think we did.
Indeed.
He wasn't a very pleasant deponent.
No. So let me just give your listeners a little taste, if they haven't read the 2025 blueprint. They intend to do away with National Public Radio, public broadcasting, and all other public radio and TV. That would just leave you as a podcaster, I guess.
Maybe.
By not only defunding them if they can, but taking away their educational status and turning their popular frequencies, because they're at the low end of the frequencies, to religious channels. That's what the future looks like. And that's just a very, very, very small part of the 2025 blueprint. So, you want to discuss other immigration cases?
I mean, kind of. This is my podcast episodes, my interviews at least, are just getting more and more negative, it seems, every week. But such is the Supreme Court these days. I'm really trying to be honest. Obviously, you have views, so do I, but I'm not. You seem to be stating facts to me. What are the other cases that you'd like to talk about?
Well, let me talk about two cases that I think affect immigration fairly directly. And they're interesting cases because one involves mifepristone, which everybody held as a good case, which actually was just a standing case. They didn't rule on the issue. They're waiting for some other case to come up after the election. And the other case involved Murphy versus Missouri. And let me tell you why I think they're important to immigration. In the mifepristone case, which was FDA versus Alliance for Hippocratic Medicine, the court set an extremely high standard for organizational standing that will undoubtedly be pulled out whenever it's convenient to deny immigration organizations challenging immigration policies. It chastised the Alliance for Hippocratic Medicine that both downstream conscience and economic injuries caused to the organization and its members by the FDA's decision to make mifepristone more easily available were too speculative and too attenuated to establish standing. The association argued that they had standing because they were, quote, incurring costs to oppose FDA action. That's a very typical argument, I think, made by immigration organizations when they've come and sued immigration for some of these. And, the Hippocratic Medicine Association argued that they had to conduct their own studies of mifepristone and to better inform the public and its members. And they had to spend, and I think this is even more important, quote, expend considerable time, energy, and resources, which is also a very typical thing argued by immigration organizations, drafting citizen petitions, as well as engaging in public advocacy and public education. And they also asserted they, quote, spent considerable resources to the detriment of other spending priorities. And that often is at the heart of what we argue as organizations in suing the government on immigration issues.
Well, you looked into it deeper. I, a bit tongue in cheek, was thinking about their claim as just a bunch of doctors who got sad anytime a woman who had an abortion came to their office. And it did seem that even at the Supreme Court, that's how they were being viewed. But your point is well taken about the spending basis for standing. We draft that all the time on our litigations, but this doesn't affect, and this is also very much in immigration litigation, this doesn't affect the standing of entities who come in and say that members of their organization have standing,
No,
right?
yeah, we're not
This doesn't
talking about
affect that.
third-party standing.
This is just
which is-
organizational in and of itself.
Right. We're talking about the organization in and of itself. But, these are tools that a court can use in any way they want, right? I mean, you're quite right that they obviously wanted to punt on mifepristone and not decide the issue before the election. And of course, the whole court did this. It wasn't just the Federalist judges. And the second case where they did something similar.
I'm sorry. Justice Kagan, I believe, was very clear at what was happening in her concurrence. Let's not just label Justices Kagan, Sotomayor, and Jackson as complacent in the politics that was played in the mifepristone case. They made very clear their concerns.
But they did concur. Okay. And then the second case was Murphy versus Missouri, which is a case challenging the content moderation policies of social media platforms. And in this case, I think they were interestingly fed up with the Fifth Circuit on standing. So they shut down their broad reading that almost anyone, anytime can bring a claim when the Fifth Circuit wants to. So they held that as an evidentiary matter, standing is required for each claim, for each defendant, and for each form of relief. They chided the Fifth Circuit for finding standing that plaintiffs will be subject to White House-induced content moderation when they did not even bring the platforms that were supposed to be modified by the government's actions before the court. They also relied on the Lyons injunction case, which has had a lot of impact in immigration, where they say, unless you can show it's going to happen prospectively, even though it happened before, unless you can show it's going to happen in the future, an injunction would be impermissible. The interesting and maybe positive part of this case was they also noted importantly that states do not have standing under the parens patriae document, which of course, has an effect on all the states bringing challenges to all the positive Biden policies on immigration.
When the doctrine of parens patriae starts getting discussed in the podcast, we know that we are deep into Professor Kurzban territory. We dove deep, I think, about 15 minutes ago. But yes, we're straight up in your class at this point.
I'll try to keep everybody awake.
No, people want to come back to law school. Absolutely. Why else are they listening to a case law podcast?
But just to show you these standing cases, how they're used in different ways, these two cases, which really set a very high bar and can be used whenever they want, they're in sharp contrast to the student loan case in Biden versus Nebraska, where the agency of the state of Missouri affected by the law refused to even bring the action, but the court found standing by the state.
I must speak up on that. I am a 37-year-old with student loans that are currently administratively controlled by MOHELA. MOHELA didn't want to defend the suit, and Missouri said, and MOHELA is completely separate from Missouri, right. But Missouri said, I believe we get tax revenue because this is a Missouri company. Are you kidding me, Justice Roberts? Are you I forget about that I have the student loans, that I'm personally involved. It offends me as a lawyer that the Chief Justice said, you know what? That's good enough. Less tax dollars to Missouri. Literally not a part of Missouri anymore. It's incredible. So agree with you on your point, your comparison of that and the standing above.
Well, if you think that one was bad, look at the web design case, 303 Creative LLC versus Elenis, where a website designer challenged Colorado's Anti-Discrimination Act, even though she never sold wedding websites, and the state never enforced its anti-discrimination law against her company.
Right.
They still found standing, and they ruled on her behalf because it involved, a religious issue. So now I get to talk about my favorite cases of the term.
What are they? Well, that's what we'll end with. The authoritarian state? Is that the corrupt authoritarian state? Is that a good way of describing them?
Fisher, Snyder, and Trump.
Oh, all in one house together.
And they all occurred within like 3 days or 4 days of each other, I think.
Yeah.
In Fisher versus United States, Chief Justice Roberts, again, upends the January 6th prosecutions by reading the obstruction statute to be limited to destruction of official documents or records. And so the obstruction statute, in his view, is only about documents and cannot be used to prosecute physical violence, intimidation, or threats against the life of the vice president and members of Congress who were voting to affirm the 2020 election. The decision has a number of direct or indirect effects on immigration, by the way. And this is, now we're really getting into the weeds. First, it affects a new use of the doctrines of Nasser Socis and Adjustum Generis by applying them across statutes, as the dissent points out, in a quite different way than they've ever been applied. And I'm not going to get into the details of it, but for those of you who are really becoming textualists, you should read that part of the dissent. I think it's of Justice Barrett, by the way, I guess, who was so appalled by their misuse of textualism to reach this conclusion that she took them on those terms. And Adjustum Generis has never been used in the way that it was used in this case. Basically the case is 18 U.S.C. 1512C2 says it makes it a crime to, quote, otherwise obstruct, influence, or impede any official proceeding or attempt to do so. C1, the first provision, involves only the destruction of documents. The Roberts Court said when they used the word otherwise obstruct, it only applied to documents. And these were, of course, the most serious charges against persons who stormed the Capitol, and C2 charges contain sentences up to 8 years. The dissent called the reading a, quote, textual backflip, quote, to find some way, any way, to improperly narrow the reach of Section C2. Aside from the public affronts to the events of January 6th, I guess the immigration consequences are tied to 101A43S, right? The obstruction of justice provision and aggravated felonies. Apparently, non-citizens charged under C2 for the acts of January 6th or comparable acts can now not be considered to be convicted of an aggravated felony.
We should be looking out for that if there are any 1512C2 convictions of non-citizens. And I mean, I guess, I don't want to be glib, but like to be convicted of 15C2, you have to be literally shredding Enron documents.
Being angry at documents.
You have to be trying to prevent an investigation into Enron in order to get convicted.
Beating up and resulting in the death of a policeman or trying to kill the vice president apparently are not obstruction by the majority.
What's up with Snyder?
Snyder, they lowered the bar to allowing criminal conduct by reading out gratuities from the bribery statute, which in light of two of the justices, at least on the Supreme Court, is not surprising, who seem to have gotten substantial gratuities over the last several years, which many were not reported.
I don't think they'd say those are even. I don't think they'd say that those are even gratuities for work already done, as is at issue in Snyder. I think that they would just say, "We are friends with billionaires, and this is what friends do. Why don't you get a billionaire friend?" I think that's what I think that's what they would say. But I digress.
Maybe. But it's interesting to me that Gorsuch, whose writing I have to say I really love, I think he's a great writer, but he was probably so embarrassed by the ridiculous rationale that the majority gave that he wrote a separate concurring opinion. And he said, quote, "Make no mistake," end quote, "this case rests only on the rule of lenity." So I guess he couldn't stomach the idea that they said something as stupid as that, oh, well, gratuities have to do with the cities and states. They are the ones who should regulate it. This is not part of the federal statute. What I loved was Justice Jackson reminds us in dissent, quote, "Officials who use their public positions for private gain threaten the integrity of our most important institutions. Greed makes governments at every level less responsive, less efficient, and less trustworthy from the perspective of the communities they serve." But the question is, what happens when a president engages in such conduct? According to Justice Roberts and his 5 Federalist justices, if his corruption is an official act of core constitutional powers, he's absolutely immune or presumptively immune from all other official acts. Trump versus the U.S., however, doesn't tell us what an official act is, or even what a core constitutional power is. If the president, let me give an example. If the president appoints a justice to the Supreme Court after taking a bribe, isn't it as an appointment an official act?
I think it is. I don't
It
think
may be
there's
a corrupt official act,
Yeah.
but we're now back to Teapot Dome era of the 1920s, which may very well be where the 6 majority justices wanted us to be. Except unlike the Secretary of Navy in Teapot Dome, the president apparently can never be prosecuted for his actions, whether they be corrupt or even treasonous. Must not be said of the decision, except that Justice Sotomayor said in dissent. I think this is all you can say about it. Quote, "It makes a mockery of the principle, foundation to our constitutional and system of government, that no man is above the law. In every use of official power, the president is now a king above the law." And, there are endless examples that abound this. For example, let me just say, the president can set up concentration camps and maybe even decide to execute Muslims, Jews, immigrants in his own brand of a final solution. Isn't immigration a core constitutional principle for which he's absolutely immune?
No.
Or he may simply ignore an injunction, and then what? Absent impeachment, he cannot be prosecuted because it was an official act. One more realistic thing, I think, and this is a horrifying one. He declares that all children born in the U.S. of non-citizen parents will be deported. He now has illegally kidnapped and removed U.S. citizens from the country. It's an official act under immigration for which he cannot be prosecuted.
No.
And we live in dangerous times, my friends.
It's very scary. What you just said evokes President Jackson, who I can't imagine anyone except supporters of the South during the Civil War in 2024 who would be pro-President Jackson. It evokes his famous, the Justice Marshall has made his decision. Oh, let's see him enforce it, and then comes the Trail of Tears. And I don't know how we got to the point where half of this country is cheering on legal philosophies that permit the Trail of Tears and just this extreme power of the executive.
I do, because it's been a 50-year project of former Birch Society family, like the Koch brothers and all the others who really wanted to change the culture of the U.S. and spent hundreds of millions of dollars, but I think it's well over $1 billion now in doing it. And they did it by giving huge amounts of money to people like Leonard Leo, who just, by the way, got another $1.6 billion to do what he did in getting Federalist judges appointed to the bench. So, there's no mistake here, and people may not want to look below the surface, and they want to still pretend that we, follow the traditional procedures, and everybody expects, respects the rule of law. But, when you look at what's happened over the last 20 years with the Federalist Society and how they, handpick people, it's very much like Latin America. So when you have one president come in and he has his judges, and then the other president comes in, he has judges on the other end, and now we're reaping the horrors of what the Federalist Society and the big money interests have brought to America.
That is pretty scary. And of course, that's not necessarily all of Latin America, but we see those asylum claims all the time. And we know better than anyone how you do not want to start messing with the judiciary, but it seems that ship has sailed, and now we are living in the beginning stages of a country that can't trust the judiciary. And on the podcast, I mean, this has all been very negative, but it's not your fault. On the podcast, I always try to turn some of the negative cases into positive when I can. And you and I have talked about this a bit. With Snyder, right? The Supreme Court has essentially said statutes that criminalize being rewarded in connection with any business transaction, some bribe after the fact, is not criminal. To me, to you, we've talked about this. That would be a very strong argument that state statutes or foreign statutes that similarly criminalize getting rewarded for activities already done while in government or not, are not particularly serious crimes, are not morally turpitudinous. This is the Supreme Court telling us what the values of America are. And the values of America say, you know what, being rewarded for things you've done while in office, flat out connected to that, and doing it knowing you were going to get rewarded, but there wasn't an express quid pro quo, you know what? That's A-OK in America. That seems to be a very strong argument that, quite frankly, we'll be making in a couple of briefs soon if there are any attorney advisor listeners. That seems like a strong argument to me. The Supreme Court is telling us what our values are. Far be it from me to disagree in my briefs. Do you agree?
Absolutely. And, that this is the time for lawyers to be as creative as possible in making the kinds of limited arguments that you can make in these circumstances. I mean, I don't want to discourage young lawyers in going forward and being aggressive and trying to change this. But I think we have an uphill battle. This is, it's ironic to me because conservatives were always complaining about activist judges. We don't want activist judges on the bench, from the Warren Court on. And now we have the most activist judges, I think, probably in American history. Overturning long-term precedents, just reaching decisions, reaching out for a decision, without even, in my view, at least, adhering to their own textualists or originalist doctrine. In other words, whenever the decision may not be consistent with a textualist or originalist approach, they just abandon it and reach the decision anyway.
It is pretty crazy that in 3 years we've gone from literally having a fundamental right to privacy over one's uterus to arguing about whether a pill approved by the FDA over 2 decades ago can withstand judgment. I mean, it's incredible how quickly this has happened, how little care there is for stare decisis on some of these long-standing pet issues of Justice Thomas, less so Justice Alito, and the Federalist Society in general. They have done exactly what they've been saying they were going to do in dissent and in the public for a long time.
And I think people should be aware of everything that Mr. Trump is saying in the public. He's been very open about what he intends to do. And one of the things he intends to do is really put the ultimate dagger in the administrative state by firing massive numbers of public employees.
It's a good segue to the end of this episode, which I very much enjoyed. And I think it's important that we immigration attorneys look at the bigger cases and how they can affect immigration, not just the immigration specific, because that's how you push the law forward and use bad decisions, maybe for humanity, to our advantage. But you mentioned what we can do. You, of course, were a founder of the Political Action Committee Immigrants List, and you're still central to it. Immigrants List, correct me if I'm wrong, is advocating for fair immigration reform on the Hill and is nonpartisan. What's going on with Immigrants List, and how can people get involved?
Well, I think we're spending a good part of our time opposing the Trump candidacy, quite frankly. And our position is stop Trump because we believe that another Trump administration would be extraordinarily harmful for immigrants. And at the same time, we're trying to support legislation that's pro-immigration and oppose legislation that's clearly anti-legislation. So we're very involved in the political process, particularly in the 7 states that are going to determine this election. We're doing a lot of ads. We invite people to go on to the website, look at the kind of work we're doing now, and join in on it. We're working with grassroots organizations around the United States, but particularly in the 7 states and in Florida and in Texas, even though there are states that may not decide this election because of the virulent anti-immigrant policies of DeSantis and Abbott. To the extent that people are interested and understand what's at stake in this election, and that stake is huge, we ask them to join us, go on the website, volunteer. If you want to give donations, that would be great. But if you just want to volunteer, that would be great, because there's a lot to do between now and November 5th.
You've also got a book out, isn't that right?
What book?
What book? The book that has your name.
Oh, that little pink book?
Yeah, that double pink book.
The double pink book. Yeah,
Was it
it's the book's coming out. It should be in everybody's hands, hopefully by the end of August or September at the latest. And it's current up to July 9th.
Yeah.
Never, I have to say, never in the history of publishing has that ever happened.
Well, you say that every 2 years when it's issued, that it's always 19 years published every 2 years, 38 years being the Encyclopedia of Immigration. That is no joke.
And it's incredible because I'm only 35.
It's amazing. You're a spring chicken. You should run for president. Yeah. Before we go, I keep asking this to anybody who's in the space, and I really am not in the space, but and it's a good way to tie up the whole episode. You talk about the Birch Society really having a 50-year focus on changing society. So when it starts advocating for these at one time extremist policies, American society, or a large portion, would be on board, and they would think that it benefits them, and really changing society to change law and to change judging. Immigration, pro-immigration, has completely failed and lost the narrative. You see what Biden was putting forward earlier this year, which had almost nothing good for non-citizens, said nothing about the DACA people, gave up the whole ship on everything the Democrats have been arguing for a while. And if I'm just being completely politically blunt, it seemed like a good political decision. It seemed like it might help his reelection. And that's a huge problem for pro-immigration advocates and their attorneys. How does Immigrants List and the other entities change American society? Because without them, we are just banging our heads on the legislative and judicial doors if you don't have society with you. Is that wrong? Is that right?
No, I think that's a terrific analysis and a terrific question about what we do. And one of the things we did when we started Immigrants List is say we're looking at the long term. We're not looking at, is this bill going to pass this year or not? Because most of the time, the truth is pro-immigration bills have had a very, very, very unsuccessful history since 1990 was the last pro-immigration bill. So the reality is, how do we change it? How do we change the culture? One of the ways is we get people elected who are pro-immigration. And in that respect, we're bipartisan and always have been. To the extent Somebody in the Republican Party is pro-immigration. Unlikely today, but maybe it will be changed in the future. But to the extent that they're willing to come forward, we're willing to support them. Obviously, most of the people we've supported are Democrats. One of the other things we do is try to get ideas beginning to be floated. For example, why don't we have a statute of limitations in immigration? Why don't we have parole in place, which we've been arguing about for a very long time, and now you see it adopted by the Biden administration? Why don't we have derivatives not counted when we issue visas? In other words, there's a whole process that's a very long process of changing that narrative by changing the people in Congress who will speak on behalf of them. And, I think we've been very successful in getting people elected. Over 70 or 80% of the people we've supported have been elected who are pro-immigration. And you have a very strong core, particularly of young members of Congress all over the country who are very supportive of immigration. I think the other part of it is, how do you change the narrative generally? And that's one of the things we've been working with AIC and AILA and other organizations to use the data that they have. For example, what does Trump always say? Immigrants are rapists, they're criminals and everything. We know factually that immigrant communities have lower crime rates than others. AIC has done a lot of work in the states and nationally to demonstrate that. So we're trying to use that, give that information to members of Congress who are going to talk about it, not just, accept it and say thank you and ignore it, but are actually going to go out there. You're absolutely right. The narrative has to be changed. It should have been changed. Early in the Biden administration, we thought it was. And then, unfortunately, the Democrats do too often what they always do as a party, which is only respond to Republican threats, intimidations, mischaracterizations of the border. We had an opportunity very early on when those people were coming to say these people are good for America. And you know why? Because in February of this year, the Congressional Budget Office said those people came across in the Great Migration will contribute enormously to the economy. They estimated in February of this year that those 2 million people who came across will create $7 trillion in the economy. They will bolster the economy by $7 trillion. Now, that narrative hasn't gotten out.
Right.
And those are the kinds of things that the Biden administration early on should have been saying. The people of the United States are absolutely right. There has to be a way to control the border. But there are lots of ways to control the border. One of those ways is when people come in, make sure they're distributed around the country where they will contribute to economic development in the United States. That doesn't mean you have an open border. You need a process where people can be judged and determined. But the problem starts with the gun manufacturers in the U.S. The problem starts with the people who are bringing them in, with the cartels. And those are the people we should be going after. Those are the people who we should say are the real cause of what's happening, because the gun manufacturers have destabilized the Northern Triangle countries. They've helped to destabilize Mexico, which is why Mexico brought a suit against the gun manufacturers in the U.S. The smugglers and the cartels, along with the smugglers, are responsible. We should have been going after them very early on and talking about the successes. And instead, all we did is respond to, Trump's claim that millions of people are coming over. And, when this started, Trump said we're being inundated by a caravan and tried to build it up. And that was 7,000 people. And I always say, if you put those 7,000 people in Viking Stadium would be empty. So it's all about public perception. We have always had more than 1 million people come across the border. We have always had people who smuggle themselves in. To the extent we have more, then we need to do something about it. We need to control the border. But the way to control that is to enlist Mexico's help, other countries' help, to go after the gun manufacturers and shut them down, to go after the smugglers and shut them down. That's the way you do it. You don't blame the victim. And of course, Trump is expert at blaming the victim.
I'm not sure what the pro-immigrant narrative is, though. I don't think it exists, and maybe one side is just better at it. I mean, I think I was just, as you were speaking, I was thinking if Donald Trump was in office and the drivers of that boat at the Baltimore Bridge event were here unlawfully, that would have been in the front page for weeks about how unlawful immigration is destroying and killing people. And it would have resulted in some legislation, some anti-immigrant legislation. They would have run with it, and it would have influenced the American public. But instead, I believe the only people who died were non-citizens, many of them here unlawfully, because they're the only ones who took the 2 a.m. shift to fix the bridge. But pro-immigration people don't really take that and run. Some people have. I saw it on LinkedIn. So there's that, not jumping at the pro stuff, always playing defense. But the final thing, I was just speaking with AILA President Kelly Stump, and I was talking about the same issue, and she brought up a good point. Like even in Oklahoma, where she's from, you start talking to somebody, and maybe they'll have anti-immigrant views, but then they'll talk about, but I got this guy. I got this guy. He's great. Like he's great at, drywall, or he's great at God knows what, or he's just a great friend. So, but not him, right? Everybody's got a guy.
Right.
If there was a whole national campaign about that guy, it could really bring America together, because I think that is something we can all agree on in this country. Let the guy stay.
No, you're absolutely right. I mean, the problem is that fear always works better than a rational explanation. And, Trump's a master at it. And so we have a tougher job, but I think you're absolutely right. I mean, I think the way to do it is to bring those human interest stories, I think the American people generally are pro-immigration. I don't care what a poll says in any one day, but the American people want order. Just like any society, they want order. They saw people coming over. It was characterized as disorder. And the Biden administration, quite frankly, missed the boat very early on in characterizing what they were going to do to bring order at the border. And that didn't mean shutting it down. And now, as a last resort, that's what he's done because of the failures over the last 3 years to execute a program that made sense to the American people and to explain to them, just like what you're saying, why did they like that drywall guy? Because we don't have enough workers in the U.S. We're down 8 million workers in this country. And you don't even hear the right wing saying they're taking your job. Trump says it because, it's Trump. Conservatives generally saying, well, they're taking your job away, which used to be the mantra of why we don't want immigrants. But the reality is they're not taking jobs. They're fulfilling jobs. They're filling jobs that we need in America. And that's why they're going to be a big boon to the economy.
Ira, we've been speaking for a very long time. It's even later in Miami than it is in San Diego. Thank you for nerding out on me on this July 12th evening. I really appreciate it. I hope everybody else does too. You remain and will always be the immigration god.
Thank you, Kevin. It's really great to be here. I hope you don't get arrested or put in some camp if Trump gets elected. I just want to say to all the listeners, these are only my views. They've been my views for years, and I take sole responsibility for it.
Oh, important thing to say.
Well, I will tell you in closing that, we get calls from people who want immigration advice, obviously, like many of the listeners to the program. And I've gotten an inordinate number of calls of people asking about how can I get a second citizenship?
Really?
Because they're truly afraid of what will happen in the Trump administration.
And on that wonderful note, we will conclude the interview. but hopefully we gave listeners some little nuggets and tools to fight in a unique way their cases and help their clients, because at base, that is what we do as immigration attorneys. Thanks a lot for being on the show, Ira.
Thank you. It's a pleasure.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.